and welcome to Moneylife. This is Sucheta Dalal. Today I'm going to speak about something different. I'm going to talk about the miscarriage of justice and the 6-year battle by one individual director against a completely shady business group and how the system can decimate you. So what is it that we are used to hearing all the time? We've seen companies that have cheated investors and their directors go scot-free. These directors have been former regulators, central bankers. Nothing ever happens to them. You've seen it happening in IL&FS, you've seen it happening in Diwan Housing, Yes Bank. Everybody just leaves the sinking ship having collected fat fees as independent directors, and there is no action. On the other hand, you have something called the Neesa group. This is a group that we in Moneylife have been writing about for several years because almost every company in the group has duped investors and fixed deposit holders. They've come up with bonds of different kinds. Nothing ever happens to the group. There is slow action. Basically, people don't get their money back. Now, this extraordinary story is about somebody who was called the managing director, which means really the buck stops at him, managing director of Neesa Technologies. And everything that I'm going to say in today's video blog is from a SAT order. And why am I emphasizing the fact that it is from the Securities Appellate Tribunal? It means that it has been heard at SEBI. Both sides have argued, not once or twice, but 2 appeals to SAT, 6 years, 2 Gujarat High Court judgments. So every side has been heard, and this is the horrific story. Now, the Neesa group of companies, like I said, has been raising money through a whole bunch of companies: Neesa Leisure, Neesa Agritech and Foods, Neesa Technologies is the one we're talking about, and Neesa Infrastructure. There are probably more that we don't know about. So in 2014, when complaints about Neesa Technologies began to mount, both SEBI and the Ministry of Corporate Affairs separately started an investigation. Since the person who is the hero of today's blog, his name is Charan Biswal, Mr. Biswal, was the managing director. Obviously, the spotlight was on him as well as other directors. So he was one of the 9 directors of Neesa Technologies. Now, here's what happens. There is a latest order which is the basis of my article, which is on 9th August 2020. But there is a 6-year battle before that. I'm going to read a lot of the stuff today because it's all legal and it's orders. So in November 2013, Neesa Technologies held apparently a recruitment interview to which Mr. Biswal appeared, and he submitted some documents. He was never appointed as the managing director, but the papers that he submitted were misused and utilized to show him as the managing director of the company. He has not attended a single board meeting and didn't even know about this mischief until he began to get letters from the RoC and SEBI, the company law board. So when he got to know about this mischief, his first job was to submit a resignation letter. He filed all the compliances to say, I'm not the MD. He had to file it at least to get out technically because he's on records. Believe it or not, the registrar of companies, for unknown reasons, does not update this for over 3 years. This has serious consequences for him. So since they're not updating it and SEBI has started action against him, issued a show cause notice, he files a writ petition in the Gujarat High Court asking for appropriate directions to say, I am no longer an MD, please put that in your records. Now, based on a court hearing that happens on 5th July 2017, the court says in the absence of any evidence, because he wasn't attending board meetings, because there was nothing on record to show that he was a managing director or had taken any decisions, they decide to fix his tenure. So instead of saying this is a fraud and push it out, they fix his tenure for 4 months from 6th March 2014, up to 6th March. So 7th November 2013 to 6th March 2014, exactly 4 months. This is updated on the RoC records. Now keep this in mind. Meanwhile, SEBI is investigating complaints about non-convertible debentures issued by Neesa. As usual, the group is not paying investors. So comes to SEBI. SEBI passes an ex parte interim order on 3rd June 2015, and this gets confirmed a year later in 2016 by a whole-time member called Prashant Saran. Typical of what happens in SEBI, there are orders issued against the whole board of directors. They say refund the money. with interest to all the investors. If the company can't liquidate, raise funds and refund it, we will go after the personal assets of the directors, which is draconian, and legitimate. Of course, if the directors are legitimate, the action is legitimate. If they participated in this mischief of conning investors, the action is legitimate. But what happens in this case? Mr. Biswal gets trapped because he is shown on the records as the managing director in SEBI as well as the RoC. So Mr. Biswal then appeals to the Securities Appellate Tribunal. The tribunal hears what he has to say and tells SEBI, by which time, of course, the Gujarat High Court has fixed his tenure for 3 months, and he says, I wasn't even around when any of this happened, and I've even challenged the fact that they call me an MD. So SAT listens to this and tells SEBI, look at what he's saying and issue fresh orders. So on 7th September 2016, Mr. Rajiv Kumar Agarwal, who is the whole-time member in SEBI, issues fresh orders, and he exonerates Mr. Biswal from all charges mentioned earlier about the non-convertible debentures. Now you would think this is the end of the story and he's home and dry, because they say he wasn't even there in the 2013 to 14 period. SAT has a long paragraph that quotes Mr. Agarwal's order, but things in real life are stranger than fiction, so it doesn't stop over there. Remember, during the hearings, the RoC continued to show him as a director. So RoC meanwhile gets active on behalf of investors, and in July 2017 it goes and issues another order. 34 criminal cases are filed against Biswal for non-payment to investors. Meanwhile, he goes back to the Gujarat High Court and he has this problem fixed. There is a tenure which is on record. But none of this actually matters, because he has to then go back and face the criminal proceedings. He goes back to the Gujarat High Court, points out that I'd come to you before. These cases are about a time when I wasn't even there. I was there for 4 months. The High Court accepts it. They in fact use a very interesting word. They say it was a paper arrangement of 4 months. He was nowhere on record. This is petition number 1117 of 2017. It quashes the 34 criminal complaints against him and says, end of the matter. No criminal complaints. There was a paper arrangement. He wasn't even there. You would think this ended the story? I mean, how much can one individual go through? But no, there is more. So now things come back to SEBI. By this time, there is another case of optionally convertible debentures. So on 30th December, SEBI issues a fresh show cause notice, not willing to take any of the previous things on record, which have come back, SEBI's own order, and says he may have been there when these debentures were issued, which may have fallen into this small window of 4 months. So the order by Anant Barua of 7th April 2020, he's a whole-time member again, is as draconian as the first one. It's against all the directors. It says pay interest at 15% to the investors, or we'll go after your personal assets. You're barred from the capital market for 4 years. So what does Mr. Biswal do? It's back to the Securities Appellate Tribunal. Luckily, in spite of COVID, SAT has been holding hearings, entertains what he has to say, listens to him, and then there is this hard-hitting order which I referred to. So instead of being back to square one, luckily within a few months after he filed, there is a strong order from the Securities Appellate Tribunal, and the appellate notes that Mr. Anand Barua couldn't, by his argument that Mr. Biswal had not attended any meetings or signed any papers, been party to all decisions. All that mattered in implicating him was that he appears to have been there when the debentures were issued and allotted. So SAT says this appears word is an erroneous presumption in arriving at a conclusion by narrating a series of facts that are on the record. And they say he's exonerated, and for all the mental harassment and trauma that he suffered, it gives him 50,000 rupees, believe it or not, insignificant 50,000 rupees as costs. In Indian courts, costs are never commensurate with damages and mental trauma, but it is supposed to be a big signal because it is against a regulator. But this horrific Kafkaesque story tells you that if you are a well-known director in a large company, high profile, maybe an IAS officer or a central banker, you get away with the biggest of scams, whether it's a collapse of a whole group called IL&FS with hundreds of companies, or a Yes Bank, or a PMC Bank, or a Diwan Housing, nothing ever happens. And this tiny, horrendous, dodgy group called Neesa, a promoter who has nothing to do with getting appointed, goes through this horror. The lesson here is that it can happen to anybody. People are hankering to be independent directors. They think it's a big prestige to be on the board of companies. You get sitting fees. Sitting fees are not high in the smaller companies and the dodgy companies. But this is the kind of egregious nonsense and chicanery that companies can get up to. And if you're caught in it, your life can be destroyed. Maybe you're not as smart as Mr. Biswal to be able to fight your way so doggedly, 2 cases in the High Court, twice before SAT, and endless appearances before SEBI. What does it say about the regulator? 3 orders by whole-time directors, which is the number 2 position in SEBI, almost on par with the chairman, can't even care, not even the humanity of looking at past orders. Believe me, anybody can be caught in this. When people think in terms of directorships, it's not just about governance rules and all the onerous responsibilities. It also is about keeping an alert eye on whether your name is being misused, whether details that you have been submitting anywhere, and the government requires all kinds of details, Aadhaar cards to be submitted, your identity can be misused. This seems to be a horrendous case like this. It's frightening, and the lessons for all of us to learn. Thank you.